year. Today we are announcing charges against 10 former National Football League players who were accused of defrauding an NFL healthcare program meant to benefit retired players and their families. These former players have been charged in 2 separate indictments with conspiracy, wire fraud, and healthcare fraud for submitting fraudulent claims to the healthcare plan for expensive medical equipment that was never purchased and never received. The cases have been indicted in Lexington in the Eastern District of Kentucky. The charges we're announcing today are merely allegations, and each of the defendants is presumed innocent until proven guilty beyond a reasonable doubt in a court of law. The Gene Upshaw NFL Player Health Reimbursement Account Plan, what I'll refer to as the plan throughout my remarks, provides for tax-free reimbursement of out-of-pocket medical care expenses incurred by eligible former players, their spouses, and their dependents. Once eligible players retire, they're not taxed on reimbursements from the plan so long as those reimbursements are for actual medical care expenses that they've incurred. As outlined in the indictment, a group of former players brazenly defrauded the plan by seeking reimbursement for expenses for expensive medical equipment that they never purchased. Things like hyperbaric oxygen chambers, ultrasound machines used by doctors' offices to conduct women's health exams, and even electromagnetic therapy devices designed for use on horses. As a result of the fraud, more than $3.9 million in phony claims were submitted to the plan, and the plan paid out approximately $3.4 million on those claims between mid-2017 and mid-2018. The 2 indictments involve different players, but the crimes charged were carried out in almost identical fashion. The ringleaders of the fraud recruited other eligible former players by offering to submit or assist in submitting fake claims to the plan. In exchange, the ringleaders demanded kickbacks ranging from a few $1,000s to $10,000 or more for each fraudulent claim that they submitted. If a participant agreed to this scheme, the leaders and recruiters obtained personal information from the players so that the information could be used to complete and submit a false claim form on their behalf. In each case, the forms submitted in support of the claim were completely fabricated. These included things like fake invoices from medical supply companies and forged letters and prescriptions from medical care providers. The exact size of each claim varied, but they were typically in the range of $40,000 to $50,000 each. When a defendant received his reimbursement check, he then kicked back the agreed upon amount to the ringleader or the recruiter. This process was repeated over and over and over again, placing the integrity of the plan at risk. By defrauding the plan and treating it like their own personal ATM, sadly, the defendants placed the plan's tax-exempt status at risk and threatened the ability of law-abiding former players to continue to receive tax-free reimbursements for legitimate medical expenses for themselves or their families. The fraud only stopped when Cigna, the insurance company that administers the plan, detected some of these claims, began refusing to pay them, and then referred the matter to the fraud section of the Department of Justice's Criminal Division for further investigation. I want to thank our partners who've worked hard on this case, the United States Attorney's Office for the Eastern District of Kentucky, including United States Attorney Rob Duncan, who is here with us today, the FBI, and particularly George Pirro, Special Agent in charge of FBI's Miami Field Office, as well as the supervisors and agents on the healthcare fraud squad who investigated this case, and multiple FBI field offices around the country who assisted with the investigation, and finally, trial attorneys in the Criminal Division's fraud section. I do want to note that the investigation is ongoing and will continue. It's now my pleasure to introduce my colleague, Robert Duncan, the United States Attorney for the Eastern District of Kentucky. Rob.
Thank you, Assistant Attorney General Benczkowski. Good morning to everyone. I am Rob Duncan. I'm the United States Attorney for the Eastern District of Kentucky. Healthcare fraud investigations and prosecutions ensure that healthcare benefits are provided to those with legitimate needs. In the cases announced today, 10 former NFL players have been indicted in 2 separate indictments and charged with developing and executing a healthcare fraud scheme designed to undermine the Gene Upshaw NFL Player Reimbursement Account Plan, a healthcare benefit program established in 2006 as part of the collective bargaining agreement between the NFL and the NFL Players Association. In addition, the government has filed notices of intent to proceed by information against 2 other players on similar charges. Now, I want to note that these charges are merely allegations, and each of the defendants charged are presumed innocent until proven guilty beyond a reasonable doubt in a court of law. As discussed in the 2 indictments, the healthcare benefit plan is intended to help former NFL players, including the defendant's former teammates and colleagues, pay for legitimate medical expenses. The plan covers medical care expenses actually incurred by plan participants, their spouses, and dependents. Participants in the plan were specifically informed that the plan excludes payment for services not yet provided. The plan also provides that participants are not taxed for either contributions to or reimbursements received from the plan. The allegedly false and fraudulent claims set forth in the indictments were all electronically transmitted from various locations across the country to a data center in Lexington, Kentucky in the Eastern District before being transmitted to employees at Cigna, the benefits administrator for the plan. Collectively, from mid-2007 until mid-2017 to mid-2018, the defendant's schemes are alleged to have resulted in the plan paying out more than $3.4 million in reimbursement payments for medical equipment that was not purchased or received. At the time these claims were submitted, it is alleged that the defendants knew that no medical care expenses had been incurred in connection with these claims. The fraud schemes, as alleged in the indictments, could have had wider implications for the plan, including the loss of the plan's tax-exempt status and implications for other former players who are beneficiaries of the plan, including depletion of plan assets. This is what the plan was designed and set up not to do. Investigating and prosecuting healthcare fraud is a priority for my office. We appreciate the partnership that we share with the Criminal Division's fraud section and the work that has gone in by their attorneys, and we also appreciate the partnership that we have with the FBI in pursuing these and other important matters. I'd now like to introduce George Pirro, Special Agent in charge of the Miami Field Office.
Thank you. Thank you. Good morning. I'm George Pirro, the Special Agent in charge of the FBI's Miami Field Office. As you've heard, earlier today, the FBI charged 12 individuals with healthcare fraud-related crimes in the Eastern District of Kentucky. This included 4 arrests, which were conducted by FBI agents from Atlanta, Georgia, Jackson, Mississippi, Washington, D.C., and Houston, Texas. These individuals are alleged to have defrauded the Gene Upshaw National Football League Player Health Reimbursement Account Plan. As part of the scheme, the co-conspirators recruited former NFL players to defraud the account by seeking compensation for durable medical equipment. Numerous individuals, including the NFL players involved, submitted claims for durable medical equipment, including items for more than $50,000 on a single claim. However, no such equipment was provided. In many cases, the medical providers and doctors had never even treated the patients involved. While this case is still ongoing, losses totaling over $3.9 million have been identified. Unfortunately, this scam is nothing new to the agents who investigate healthcare fraud in Miami Division. South Florida is ground zero for healthcare fraud in the United States. Each year, fraudsters in South Florida swindle the federal government out of hundreds of millions of dollars, money intended to treat the ill and infirm through programs such as Medicare and Medicaid. I want to commend the diligence and dedication of the FBI agents around the country who participated in the arrests this morning and the 20-plus FBI field offices who assisted with this year-long investigation. I especially want to recognize my healthcare fraud investigative team in Miami who has been tirelessly investigating this scheme. Those who perpetrate scams to steal taxpayer dollars from intended beneficiaries, threaten the viability of critical health care programs. We are committed to rooting out these fraudsters. This morning's arrest demonstrates that the FBI will not tolerate stealing money meant for health care, no matter who's involved. Thank you.
Questions?
Yeah, hi, I have two questions. One is about the medical providers. You mentioned that some of them had not treated the players. Is this a situation where their ID numbers and information were stolen and used without the doctor's knowledge, or were there doctors who were complicit in writing, prescriptions and things for them to be able to file these claims? And second of all, you said there's an ongoing investigation. Is there any reason to believe that current NFL players are engaging or have engaged in this scheme as well?
As to your first question, we have no evidence that there's any doctor complicity here. In each case indicted in these two each claim indicted as part of these two indictments, the communications from the physicians, either prescriptions or physician authorizations for the medical equipment or medical treatment, were fraudulently obtained. They were forged. This is a plan, it's got about $800 million in it, that benefits former NFL players. Players who, after their initial period when they leave their service to the league, they get a certain type of health care, and then this kicks in later on after that. So we have no reason to believe at this point, although the investigation is ongoing, that there are any current players involved in any of this.
Can you talk a little bit about the alleged fraud that was initially detected by Cigna, how they were able to detect this fraud and how they passed it on to you all?
We work with insurers all the time on the private side. As George mentioned, we do a lot of work on Medicare and Medicaid, and we use data analytics to do that kind of work. But we also rely very heavily on private insurers, and we investigate private insurance fraud as well. In this instance, they saw anomalies in the types of claims that were being filed. As I noted, on more than one occasion, there were claims filed for very expensive equipment that's used to treat horses. And so when you see something like that as a claims administrator, it tends to draw your attention. And it went from there.
Which arrests were executed this morning and are more planned?
As you know, there are 10 individuals charged in two separate indictments today. There were 4 individuals arrested. 6 have agreed voluntarily to appear and self-surrender. And so I don't think I want to get into which 4 were arrested versus the others who have agreed to self-surrender. But as in any case, we interact with the potential defendants, and those who interacted with us and expressed the desire to self-surrender, that happened. Those players who did not interact with us, we were forced to arrest.
Can you speak to the criminal information that is going to be filed against those players and exactly what they are accused of doing?
Rob, you want to take that?
So as I mentioned a moment ago, the government has filed notices of intent to proceed by criminal information, and the 2 players are scheduled for further proceedings in the Eastern District next week.
Can you just explain again why, since they were stealing from the NFL and not the government expressly, like what was the reason to pursue this particular case, which is, just 3.4 million? I mean, not just 3.4 million, but usually you see higher sums.
We pursue private health insurance fraud all the time at the department. This is an $800 million or so plan intended to provide benefits to law-abiding former players and their families. And this conduct, if it had gone unchecked, threatened the tax-exempt status of the fund, and also then created potentially, and I'm not a tax and benefits lawyer, so I'm not going to get too far out over my skis on this, but as I understand it, the players who had received distributions from the plan for legitimate medical expenses previously, if the tax-exempt status of the fund were threatened, it would create problems with respect to those distributions, and would obviously mean going forward that players who were going to receive distributions from the fund from here on out wouldn't be able to get the full benefit of those distributions because some of them would have to be taxed.
These players all run in different circles, different teams. Is there anything you can say about sort of how the ringleaders recruited the players and how they sort of came together for this scheme?
The ringleaders, this is very much like a typical healthcare fraud scheme. There were two ringleaders. The second ringleader learned of the scheme from the first, was a participant in the first conspiracy. Those individuals then recruited recruiters. They found recruiters who would then reach out to former players who they knew to offer them the opportunity to be part of the conspiracy and get these payments. And so it looks just like a traditional healthcare fraud scheme. You have a ringleader at the top, you have recruiters down below, and then you have what would normally be patients in a typical healthcare fraud scheme. And in this case, there were former players.
You mentioned the investigation is ongoing. Do you anticipate any additional arrests?
It's ongoing, and we're going to follow the facts wherever they lead. And if we develop additional evidence of either additional individuals who are participants in the conspiracies that have already been indicted or additional conspiracies to do the same thing, then obviously there will be more arrests and more charges.
Were there any players that were unwittingly roped into this, that claims were filed on their behalf that they weren't aware of?
The individuals who've been charged in these two indictments, we allege were aware that the claims had been submitted on their behalf. They received the checks, provided kickbacks up the chain to the organizer and the runners. And so at this point, anybody who's been charged, we are confident that we would be able to prove that they had knowledge that that they were part of the fraudulent scheme.
So the indictment has several people mentioned just by initials. Should we assume, or can you tell us, are there other players that, is the ring much larger than the 10 people?
Well, let's take a step back. The first indictment has 3 initials in it. One of the sets of initials corresponds to an individual who was named in the second indictment. And that's reflective of the fact that the first indictment came first, and we have a policy at the department of not naming unindicted co-conspirators. So in that first document, the first indictment, one of the individuals is referenced by initials, and then he's named by name in the second indictment. So that's just a function of which indictment came first. The other 2 individuals who are mentioned by initials in the first indictment are individuals who Rob mentioned, for whom we've filed paperwork with an intent to file criminal information in the Eastern District of Kentucky. I think if you look at the initials of those 2 other players in the first indictment, and you look at the 2 players for whom we intend to proceed against by information, those match up.
One of the individuals charged is Clinton Portis. He's been public in the past about having filed bankruptcy after leaving the NFL and having had thoughts about being driven to potential murder. Can you talk about this kind of culture that's developed among these NFL players, a lot of whom are driven to bankruptcy, and what's your message to them, just to, kind of, that have to feel like they have to get involved in crimes to make money?
I'm not aware of the financial circumstances of any of the players we've indicted here today. I will say this, that when we investigate and prosecute healthcare fraud, we find that defendants who commit this kind of fraud do so for a variety of reasons. The bottom line is we proceeded here in this case because of the potential impact that these crimes, not only the amount of money at stake, but the fact that the crimes potentially impacted a very important benefit that was collectively bargained between the league and the Players Association to benefit former players and their spouses and their dependents. So whatever the motivation of any of these folks was, in my mind, that's irrelevant. What's important in my mind here is to be able to protect this important benefit that the league and the Players Association collectively bargained for to benefit former players.
Has the league and the NFLPA been cooperating with this investigation?
They are aware, and they were aware of what we were announcing today. They're both very sophisticated organizations, and I don't purport to speak for either the league or the Players Association, except to say that they were aware of what was coming today. Anything else? Thank you all.